have required me to, or my children, to think about and see things that children should not have to see or think about. One example is when threats to my life were particularly intense a few years ago around the time of the Dobbs leak. My security detail sent me home with a bulletproof vest, and I carried it into my house, put it into my bedroom, dropped it down on a table, turned around, and my 12-year-old son was standing in the doorway of my bedroom, and he wanted to know what it was and why I had it, and I didn't know how to respond because maybe I lack imagination, but I didn't expect that performing this service was going to put me in the position of explaining to my children what a bulletproof vest was and why I had to wear one. It's also been reported in the news that roughly 6 weeks ago, I was the victim of a swatting incident. At that point, my teenage son, one of my teenage sons, opened the door to go out with friends and saw in our street, it was full of police cars, who had responded to a false report of gunshots and raised voices in my home. I was very, very grateful that I had Supreme Court police outside my home because they were able to stop and meet with and explain to the county police that it had been a false alarm, and so the police did not actually attempt to enter our home. Many of us, me included, have received threatening anonymous deliveries designed to intimidate and harass us. They are often sent in the name of Judge Salas's son, who I think, as you mentioned in the beginning, Mr. Chairman, is deceased because he was killed by a disgruntled lawyer who showed up at Judge Salas's home intending to kill her, but her son, 20 years old at the time, opened the door and took the bullet instead. Her husband, standing behind, was seriously injured. So I think the message on these deliveries being sent in his name is clear. As Justice Kagan said, federal judges across the country, throughout the judiciary, including the Supreme Court, continue to do their jobs without fear or favor, but the threat level is really high.
Few institutions in the United States carry as much constitutional responsibility as the Supreme Court. Unlike Congress, whose members face election every 2 or 6 years, or the President, who remains accountable to voters every 4 years, Supreme Court justices are appointed for life. The framers intentionally designed the judiciary to be insulated from the shifting winds of public opinion, political pressure, and partisan passions. The court was meant to be the nation's impartial interpreter of the Constitution, guided by law rather than popularity, political expediency, or fear. This independence is not merely an administrative convenience. It is one of the central pillars supporting the American constitutional system. Alexander Hamilton famously argued in Federalist No. 78 that the judiciary would possess neither force nor will, but merely judgment. The court's authority depends almost entirely upon the public's confidence that its decisions are reached honestly, independently, and according to constitutional principles. Yet, the modern political climate presents new and unprecedented challenges to judicial independence. The United States has become increasingly polarized. Judicial decisions no longer generate only legal debate. They often provoke intense political reactions, nationwide demonstrations, online harassment, personal threats, and in some cases, acts of violence. Members of the judiciary now operate in an environment where controversial rulings can instantly trigger coordinated campaigns of outrage amplified through social media, 24 hours news coverage, and sophisticated digital technologies. Recent public discussions have highlighted growing concerns about the personal security of federal judges and Supreme Court justices. Increased security measures, threats against judges and their families, online intimidation, and attempts to expose personal information have all underscored the reality that judges are not immune from the broader political tensions affecting American society. These developments raise broader constitutional questions that deserve careful examination. If judges increasingly face intimidation, can the judiciary remain truly independent? How resilient are constitutional institutions when those entrusted with interpreting the law become targets themselves? What safeguards exist to ensure that judicial decision-making remains free from improper influence? These questions are not accusations directed at any individual justice. Nor do they suggest that any particular Supreme Court decision was influenced by threats or intimidation. There is no public evidence demonstrating that any justice has altered a judicial opinion because of personal safety concerns. Nevertheless, constitutional systems are strengthened not merely by addressing proven failures, but also by examining potential vulnerabilities before they become crises. So in this video, we are going to explore those broader institutional questions. We are going to examine why judicial independence remains essential to constitutional government, how modern threats differ from those faced throughout most of American history, the theoretical risks posed by sustained intimidation, and the constitutional safeguards designed to preserve the integrity of the nation's highest court. Ultimately, this is not a video about any single case or any individual justice. It is a video about protecting one of America's most important democratic institutions. The American constitutional system rests upon an intentional separation of powers. The framers divided government authority among three independent branches: the legislative branch, the executive branch, and the judiciary. Each branch possesses distinct constitutional responsibilities, limiting the power of the others through a carefully constructed system of checks and balances. Within this framework, the judiciary occupies a unique position. Unlike elected officials, federal judges do not campaign for office, seek political endorsement, or appeal to voters for re-election. Their legitimacy derives not from democratic popularity, but from faithful interpretation of the Constitution and federal law. Recognizing this unique responsibility, the Constitution provides several important protections designed to preserve judicial independence. Federal judges receive life tenure during good behavior. Their salaries cannot be reduced while they remain in office. Their removal requires impeachment by the House of Representatives and conviction by the Senate, an intentionally difficult process designed to shield judges from political retaliation. These protections were revolutionary for their time. The framers understood that judges who feared losing their jobs after unpopular decisions could never function as genuine constitutional guardians. Instead, judges needed sufficient independence to rule according to law, even when doing so proved politically unpopular. Hamilton addressed this concern directly in Federalist No. 78, arguing that judicial independence serves not the interests of judges themselves, but the liberty of the people. He recognized that constitutional rights would become meaningless if judges lacked the courage or institutional protection necessary to enforce them against powerful political actors. Throughout American history, this principle has repeatedly been tested. Supreme Court decisions have often generated enormous political controversy. Cases involving slavery, segregation, civil rights, abortion, executive authority, religious liberty, and federalism have each produced passionate disagreement. Yet, regardless of one's political views, the legitimacy of those decisions ultimately depends upon public confidence that they were reached through legal reasoning rather than political intimidation. Once citizens begin believing judges decide cases because they fear retaliation rather than because they believe the law requires a particular outcome, the constitutional foundation supporting judicial authority begins to weaken. The court possesses no army. It commands no police force. Its authority depends almost entirely upon institutional credibility, and that credibility in turn depends upon independence. Judicial independence is often misunderstood. Many assume it exists primarily to protect judges, but in reality, it exists to protect the Constitution itself. Every constitutional democracy eventually encounters moments when popular opinion conflicts with constitutional principles. Sometimes, majorities demand policies that conflict with individual rights. Sometimes, elected officials seek powers beyond constitutional limits. Sometimes, intense political passions threaten to overwhelm legal restraint. During such moments, the judiciary serves as the nation's constitutional referee. Its responsibility is not to satisfy public opinion. Its responsibility is to determine what the Constitution permits. This function necessarily requires independence. A judge who fears political retaliation cannot effectively limit governmental power. A judge who worries about personal safety when issuing controversial decisions may face pressures unknown to previous generations. Although there is no evidence that today's Supreme Court justices decide cases based upon fear, constitutional scholars increasingly recognize that persistent threats against members of the judiciary represent institutional concerns worthy of serious discussion. The issue extends beyond physical violence. Modern intimidation can take many forms: online harassment, coordinated misinformation campaigns, publication of personal information, threats directed towards spouses or children, harassment at private residences, false emergency reports designed to trigger armed police responses, cyber attacks targeting personal communications, and attempts to damage professional reputations. Each incident may appear isolated. Collectively, However, they create an environment fundamentally different from the one envisioned by the Constitution's framers. The question is not whether judges should possess extraordinary courage. They should. The question is whether any constitutional system should expect judges to carry the burden of sustained intimidation without providing sufficient institutional protection. A judiciary consistently forced to focus upon personal security risks cannot devote its full attention to constitutional interpretation. Protecting judges ultimately protects the public's confidence that judicial decisions remain independent. This principle benefits citizens, regardless of political affiliation. Every American, whether conservative, liberal, or independent, possesses an equal interest in ensuring that judges decide cases according to law rather than external pressure. For if intimidation ever becomes an effective means of influencing judicial behavior, every constitutional right becomes less secure.